I'm Jeromy West. I'm a licensed attorney in Arizona and New Mexico, and I'm here to tell you some crazy stuff about one of my favorite law shows. We're reviewing Suits Season 1, Episode 1. I want to tell you some of the stuff that's real and some of the stuff that's not so real here.
Time's up. Pencils down. Excuse me. Do I know you from somewhere?
No, I don't think so. A pretty good memory for face.
Uh-huh.
Also need this.
So do I.
Well, they could have
Right. Sorry.
I got it.
You're bargaining.
Actually,
I
That the car ants. They get killed.
I'll get it.
They get the leaves and it's a couple rounds.
Yeah.
That's the student. It's talking about it.
Well, the test finishes, and Mike goes to the front, and he hands in his test, and the proctor grabs his test and says, "Oh, haven't I seen you before?" Insinuating that there's a problem, right? And he keeps his test separate. Well, Mike shuffles it into the pile really quick and gets away, okay? But what they're wanting you to think is that there's a problem because the proctor knows, oh, Mike's taken the LSAT before. Well, you're actually allowed to take the LSAT. I haven't checked on it lately, but it's something like 7 times in your lifetime and 3 times in 1 calendar year. So the insinuation of the show is that this guy knows he's seen him, before, but really, if it were reality, he would have to be sure that he's seen him more than 4 times or more in 1 calendar year, or 8 times or more in his lifetime. Now, that's the first problem. The second problem is that just in my home state of Arizona, I went and checked it out. There's something like 7 different places that you can take the LSAT. So, each school of law that we have has their own place, and then some of the community colleges have their own place. The show takes place in New York City. I'm assuming he probably has 15 or 20 places close by that he could take the LSAT that all would have different proctors. So, I mean, theoretically, and I'm not encouraging anybody to do this, very bad idea, free legal advice, don't. But theoretically, he could go and take the LSAT 3 times at each one of those locations and maybe not even get recognized. And even if he was recognized, there wouldn't be a problem with it. So, not the most realistic scene in the whole world, but again, hey, we like drama, and that definitely added some drama.
Your Honor, this case should be thrown out. Other than her story, the plaintiff doesn't have one piece of evidence.
Because the evidence lies within their personnel files, which they're conveniently refusing to hand over.
Those files contain sensitive information. He's fishing at the expense of our employees' right to privacy.
Please. They don't give a rat's ass about his employees' right to privacy. Sorry, that's actually unfair to rat's asses.
Your Honor, Mr. Spector's claim that we don't care about our employees, though belittling, doesn't carry any weight as a rule of law.
Okay, now I'm going to start by telling you, I could make the same complaint about just about every courtroom drama out there. Before I do, I'm going to tell you that without this kind of thing, there are no courtroom dramas. There's just courtroom, because the way that this actually works is really boring. They're both presenting arguments. One of them has filed a motion to dismiss. One of them has filed an answer to that motion to dismiss. Harvey is arguing against the motion to dismiss. They want the claim to move forward. They're both standing behind their tables. They're arguing back and forth. They're arguing sort of with and against the judge. Harvey starts walking all over the courtroom. None of this happens. Let me describe to you exactly how boring courtroom argument actually is. If it's my motion to dismiss, I stand up, I have some time, maybe I'm on a timer, maybe I'm not, depending on the courtroom and what their rules are locally, but I stand up, I present my argument for the motion to dismiss, and then I'll sit down, other side will stand up, present their argument against the motion to dismiss. They'll finish up, they'll sit down. The other guy might have a rebuttal, and then you might even have a rebuttal against the rebuttal. But they're never arguing at each other, and it's very just mundane. The law says this. There's a case very similar, and it says this. And basically telling the judge, you should fine for us because that's what these other cases that are similar said. Okay. Never going back and forth. But at the end of this, there's another I won't say never, but almost never. On a motion to dismiss, I've never even heard of it happening in any courtroom anywhere. And that is the judge just announces what his decision is after hearing both arguments. I've seen a judge just give what their decision is on a very simple motion, like a motion to continue, which is just saying, can we reschedule today's hearing for later on? Really simple things like that. They'll say, yeah, let's go ahead and do that right now, and they'll give you a decision. A motion to dismiss, they're probably going to want to go back to their chambers. They're going to want to give both of those motions to their law clerks. They're going to want to say, oh, by the way, Harvey out there says XYZ and the other guy says ABC. Look in the law and see which one of those is, more accurate, or, they're going to ask to see those cases. Then after all that research, finally, they're going to write a decision and they're going to send it out. Okay. It's called a ruling, right? They're going to write their ruling. They're going to send it out to both parties, and then they'll actually know what the judge thinks. Did the case get dismissed or not? I have seen motions, especially in-depth motions like you would do for a motion to dismiss, that have been weeks or even months to rule on. But just in the courtroom saying, no, I've had enough. This case is going forward. Never once in my career have I ever seen anything like that. So, big fail there. But it's super dramatic, and we love to watch it.
And expect.
They're trying to bury you in paperwork.
Well,
Yep.
okay. They picked the wrong guy.
If they didn't, I did. Get it done by the end of the week. I got to run and try my new client.
No, good night.
Scan QR, the ART.
And a lot of people might look at this and go, yeah, right, never happened. Actually, they're suing here a big corporation. From what they make it sound like, is a very big corporation. My first job in the law was document review. And I was reviewing documents for a huge lawsuit. I obviously can't talk much about it, but it involved a major corporation. And that major corporation was responding to a request for production. That just means, hey, we would like to see all of your documents that are related to these things, right? Or it might say we want to see all of your emails which discuss these subjects. Okay, so we're responding to this request for production, and our client presented us, the document review team, with hundreds of thousands of emails to review. And out of those hundreds of thousands of emails, if I remember right, most of them went to the other side. There's a couple of reasons. Number one, the requests for productions frequently are written very broad because you want to make sure you get everything. But at the same time, the other side's strategy there is to say, okay, you want everything? Here's everything. You get a look at 10 million sheets of paper and try to find what you're looking for. That's just basically called burying them in discovery, right? And in this case, they're saying, oh, we've got to look all through it because we've got a hearing in a week. Well, that, by the way, is probably the most unrealistic part about that scene. I have never seen in my life a hearing that we've just decided the case is moving forward, and you get a week to prove why it's going to move forward and to find everything that you're looking for. So that's not the most realistic part of it. But all of those documents, all those boxes, yeah, that's real.
Do you have anything to do with the March 12th, 2005 files left out of discovery? If they're here by noon, I'll believe you. If not, we're filing for sanctions. Threat of sanctions is better than filing for sanctions.
That's what I meant. Threaten, not file. Who would mean that?
Harvey picks up the phone and says, hey, I'm going to file sanctions if you don't send us what's missing. And then he hangs up and he says, threatening sanctions is better than filing for sanctions. Well, yeah, especially since at least in Arizona, you're required to. So we have in our Arizona Civil Rules of Procedure, Rule 11 is a motion for sanctions, and it actually says that you're required to try to contact the other party to get them to resolve the situation before you file a motion for sanctions. Judges hate discovery disputes. Now, we love them in courtroom dramas because they're very dramatic, but judges absolutely hate them. So most of our rules actually lean toward just saying, figure it out on your own. Call the other party and say, did you mean to send me a photo and you forgot to? Or did you mean to send me this because I don't have it? And try to figure it out. And then tell them, look, if I don't get it, I'm going to have to file for sanctions. I need that. And then you actually file a motion for sanctions. And sanctions, by the way, could go all the way from you're actually paying something to just saying, they might have a motion to compel goes before that and saying, you just have to produce it. The court saying you have to produce it, get it done. And sanctions could be economic sanctions where you have to pay the other side's court costs, right? Their attorney's fees and everything because you messed up and we had to spend extra time on it and it shouldn't cost that client any money. So it's legit. And what he said here is legit. It's just not, it's better. It's actually the rules require it.
Is money, but witness tampering, that's a crime. And you will go to prison, where I guarantee you'll learn more about unwanted sexual advances than you could possibly imagine.
Do you think this is going to intimidate me? Even if this evidence was credible, who are you going to get to prosecute a small-time witness tampering charge, huh?
Okay, so let me tell you a couple things. I actually had an experience where I was defending a client, and all of a sudden, he tells me, hey, I think the case is going to get dismissed. I'm like, okay, why? Oh, the alleged victim is going to withdraw her statement. So I'm going, okay, well, that's not good. How do we know that? And then I get a call. I call the prosecutor and I say, hey, I heard that the alleged victim is going to withdraw her statement. Do you know what's going on there? And he said, yeah. I've got recordings of your client calling our client trying to convince her not to testify. Not good. And he basically said, if she doesn't testify, each one of those phone calls is going to be one count of witness tampering. I think there were 29 phone calls. So 29 counts of witness tampering, which were misdemeanors. Maximum penalty in Arizona is 6 months for a Class 1 misdemeanor and a $2,500 fine. They don't usually stack them all up on top of each other and go 6 months plus 6 months plus 6 months. So, he probably theoretically wasn't looking at 15 years for that. But would I be surprised to get see a judge that just totally threw the book at him given the situation? No, I wouldn't have. And when I brought those recordings to the client, he asked what the current plea offer was, and I showed it to him, and he decided to accept the current plea offer. So when suits ask, do you really think that they're going to be interested in a little witness tampering case? Yeah, under the right circumstances, if that's what they can get against somebody, they're going to be very interested in it. Okay. Now, the other thing that I saw here was that when they walk into the courtroom, they're all sitting in the back, and they're trying to settle the case like 10 seconds before a hearing starts. That might happen, but if they have information, they're going to pick up the phone and call the other side right then. They're not going to wait until it's 10 seconds before the hearing. But once again, we like drama, so we want it to happen in the courtroom right at the, just before the final bell and makes it all look really good. But really, this probably would have been an email or a phone call, and we would have just settled it beforehand. So that's Suits Season 1, Episode 1, one of my favorite law shows of all time. As you can see, there's some stuff that's real, some stuff that's not, but still a really great show. So if there's a show that you want me to review, a show, an episode, a movie, put it in the comments. I'd love to record an episode for you. I'm Jeromy West with Civitas Law Group.